Good afternoon, Mr. Zhu. How are you? State Ram, do you have Mr. Cabrera Alonzo set up? While she's setting up Mr. Cabrera, let me go ahead and place you under oath, Mr. Zhu. If you will go ahead and state your name and your license number for the record. All right, Mr. Zhu, do you solemnly swear or affirm that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given in this matter to the best of your skill and judgment, so help you God? All right, thank you. Yes, ma'am. Let me know if you get a good connection. Do you have him unmuted, Mr. Abraham?
Yes, Your Honor. The laptop is unmuted.
All right, well, make sure that he doesn't have it clicked on the inline microphone because she's not hearing him.
Hey.
Mr. Zhu, do you have communication with him now? Okay. Okay, all right. Court calls cause number CR 21-207, State of Texas versus Carlos Cabrera Alonzo and Mr. Schmidt. We are set today on the motion to revoke. Any announcements?
Yeah, Judge, we're going to ask for an additional setting. Mr. Cabrera Alonzo speaks no English. My Spanish is pretty poor. There are quite a few allegations in the state's motion to adjudicate his community supervision, which are also in English. He does not read English. I have my own interpreter, but she is only available sporadically. And I need more time to bring her in so that I can explain to him and he can explain to me what's going on, including potential resolution of this case.
Okay, any objection from the state?
No objection, Your Honor.
All right, the court will reset Mr. Cabrera Alonzo to March 27th. That is our next contested date for the motions to revoke. Mr. Schmidt, do you believe that'll give you enough time to get your interpreter in and be able to speak with your client?
Yes, sir. We'll make it happen.
Does your client, Mr. Cabrera Alonzo, do you have any questions of Mr. Schmidt or the court?
No.
All right, very well. We'll see you back then on March 27th.
That's it.
All right, Mr. Zhu, I think that concludes our need for your services today. Thank you for being here. Really appreciate you. You as well.
We'll go back. Yes, he's
All right, Mr. Schmidt, are you ready on anyone else?
Jacob Hall.
Mr. Hall, if you'll come forward. This is cause numbers CR 24-136, CR 24-28, State of Texas versus Jacob Thomas Hall. Are we entering a plea today, Mr. Schmidt?
We are, Judge.
All right, Mr. Hall, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Jacob Thomas Hall?
Yes, sir.
And Mr. Hall, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir.
Do you have any questions about your plea agreement or any of the documents that you've signed today?
No, sir.
Where you have signed these documents, Mr. Hall, is that your true and correct signature that you placed there once you understood what you were signing?
Yes, sir.
All right, Mr. Schmidt, do you believe your client to be competent today? And if so, have you explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Hall, you were originally charged with two crimes, one being a second-degree sexual assault. You were charged by indictment, and that caused CR 24-136. I see the state has filed a motion to dismiss that case today, and they've also filed a continuous violence against the family by information, a third-degree felony. The first thing we need to talk about, Mr. Hall, is that you understand that you have the right to have this case indicted by the grand jury. Do you understand that?
Yes, sir.
And do you understand that in order for the DA's office, the state of Texas, to prosecute you for this crime, the case has to be presented to the grand jury. The grand jury has to evaluate the evidence and make a determination on whether or not they believe that it's more likely than not, with probable cause, that you committed the offense. And that's the only way that they can prosecute you for this, unless you waive your right to an indictment. Is it my understanding that you're wanting to waive your right to an indictment by the grand jury and allow the state to file these charges in court directly by way of filing an information? Is that true?
Yes, sir.
Okay, and you've spoken with your attorney, Mr. Schmidt, about this, and you believe you understand the important rights that you're giving up?
Yes, sir.
And have you made this decision to waive your right to a grand jury indictment? Have you made that independently without being forced, pressured, or otherwise made to believe that you had to do that?
Yes, sir.
All right. Mr. Schmidt, you've counseled your client on waiving his right of an indictment.
Yes.
And do you believe that he has made his choice to waive his right to an indictment intentionally, knowingly, voluntarily?
I do.
All right, court will approve the waiver of indictment, allow the state to continue its prosecution on the basis of an information. In cause number CR 25-28, Mr. Hall, you are charged by information with a third-degree felony offense of continuous violence against the family. A third-degree felony does have a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case appears to be that you would be willing to plead guilty to that crime in exchange for the state's recommendation that the court consider the evidence but not convict you of the offense, but rather place you on 6 years of community supervision. You would also be responsible for a $1,200 fine, $290 in court cost, $515 in reimbursement fees, and restitution in the amount of $925.79. It also appears as part of the agreement that the DA's office is agreeing to reject and not pursue an aggravated assault causes serious bodily injury, a terroristic threat of a family or household member, dismissal of the other indicted cause, sexual assault, and also weapon forfeiture, and requiring you to be placed on the mental health caseload as a condition of your community supervision. And in addition to that, an agreement that a protective order will be placed for the protection of the alleged victim in this case. Is that your understanding of the agreement, Mr. Hall?
Yes, sir.
All right, any questions about any of that before we go forward?
No, sir.
Okay, all right, then, Mr. Hall, how do you plead to continuous violence against the family?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Hall, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence supporting the plea?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, state is in compliance with victim contact. Victim was hesitant to support this plea, however, with the protective order in place and the conditions of probation, the services that Mr. Hall would have access to on probation, she was accepting of the plea.
All right, thank you, Mr. Harwell. Anything further from the defense, Mr. Schmidt?
No, sir.
All right, court is reviewing the evidence. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement and recommendation of the DA's office. The court hereby defers the finding of guilt on the third-degree felony offense of continuous violence against the family. Court places Mr. Hall on 6 years community supervision, orders him to pay a $1,200 fine, $290 court cost, $515 reimbursement fees, restitution in the amount of $925.79. Restitution being payable to the inmate medical restitution account for Van Zandt County Indigent Healthcare. In addition, the court hereby places Mr. Hall on the mental health caseload for community supervision to include a substance abuse evaluation. The court also forfeits the weapon seized in this matter or related matter, and that being outlined in the judgment as a Starfire, a black 9mm semi-automatic handgun. Further, the court does grant the protective order, which is part of the agreement in this criminal case, and the court takes under consideration and dismisses pursuant to section 1245 of the Texas Penal Code, aggravated assault cause of serious bodily injury, unfiled DA 2024-0402, unfiled terroristic threat of a family or household member, DA 2024-0404, and the court dismisses the sexual assault indicted in cause number CR 24-136. Mr. Hall, you're hereby remanded to the custody of the probation department for them to carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll meet with the probation officers about more information.
Yes, sir.
Mr. Manning, who are you ready on?
Judge, ready on Mr. Joseph Michael Howe.
All right, this is cause number CR 22-26, State of Texas versus Joseph Michael Howell. Motion to revoke. Go ahead, Mr. Manning.
Yes, Judge. The state and defense have reached an agreement with which they will draw and continue with the amendments to probation, being that they updated the financials. He will be extended for a period of 2 years, which will extend him out until May 2029. He will begin paying his probation fees and UA fees starting in June 1st. I'm sorry, they extended the probation and UA fees in June 1st of 2027. And he submits to a period of 158 days with credit for time served as a condition of probation.
Did you say 158, 158 or 150?
150, Judge.
150, okay. All right, Mr. Howell, tell me why I should allow you to enter into an agreement with the state to go back on probation when you violated the terms and conditions of the community supervision. Why should I give you this opportunity rather than just sending you to prison?
Well, sir, I did make a mistake there by a bad choice of words, and the original offense, but if you can give me another chance, I will show you that it won't happen again. I'll be on my A's and B's, and do what's right, and just focus on myself, pay my fines, and not get in any more trouble.
What's your motivation to do that?
Well, from before, I was focused on a relationship that turned out to be bad, and I seemed to get ahead of myself. So my plan is to get out, work, pay the fines, and work on myself and move on.
All right, Mr. House, this is gonna be your last opportunity. You show back up in my court on a motion to revoke, we're just gonna have a hearing.
Yes, sir.
There's not gonna be any more agreements going forward. Just gonna be a hearing and then I'll decide what's gonna happen to you. Understand? All right, court hereby grants the state's motion to withdraw, and the court will approve the agreement to extend the conditions of community supervision period for an additional 2 years. The court orders him to pay, or I'm sorry, the court orders him to serve 150 days in the county jail as a condition of his community supervision. Court will give him credit for that time served. And the court will amend his financials to reflect the filing of this case in addition to any remaining balance currently. All right. It's time for you to do what you say you're going to do, Mr. Howell.
Thanks, sir.
Who's next, Mr. Mans?
Judge, whatever your preference is, I have Mr. Saunders, I have Ms. Saunders' paperwork here, in paperwork form, or we also have an electronic plea for Mr. Rogers, Joshua Rogers.
Okay, I didn't know we were gonna have electronic plea. I'll have to go get my tablet for that.
Judge, we were unaware, as well, so, but I, just to let you know that is in queue. We completed the paperwork, signed that paperwork, and it'll be ready.
Okay, so you said you're ready on Saunders?
Yes, Judge.
Right, this is cause number CR 23-40, State of Texas versus Haley Delane Saunders. Ms. Saunders, if you'll raise your right hand, I'm going to place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, you are Haley Delane, is it Delaney or Delane? Delane Saunders. And Ms. Saunders, are you well, let's see, you are currently on probation in my court, is that correct?
Yes, sir.
And it appears to me that on March 9th of 2023, you appeared in this court. You pled guilty to aggravated assault with a deadly weapon, a second-degree felony. The court heard the evidence, and then the court followed the plea agreement that you reached with the DA's office. And the court followed it by placing you on deferred adjudication for a period of 10 years and assessing a $2,000 fine. It seems that the state filed a motion to adjudicate. That means to adjudicate your guilt or to convict you and to revoke your community supervision on January 29th of 2025. And they alleged what appears to be 5 separate counts of violations. Have you had enough time to review those allegations with your attorney, Mr. Jonathan Manning?
Yes, Your Honor.
Are you pleased with Mr. Manning and the work that he's done for you in this case?
Yes, Your Honor.
Do you understand everything that you've read and signed today in your paperwork?
Yes, Your Honor.
And when you sign the paperwork, is that your true and correct signature?
Yes, Your Honor.
All right, Mr. Manning, do you believe Ms. Saunders to be competent today to enter into this agreement?
I do, Judge.
And do you believe that she is entering into it intentionally, knowingly, and voluntarily?
Yes.
All right, Ms. Saunders, does your client also waive the formal reading of the state's motion to adjudicate?
She does.
And is she pleading true to all counts?
Yes, Judge.
Okay. All right, then, it looks like the plea agreement is upon your plea of true, Ms. Saunders. The DA's office is recommending to the court that your guilt be adjudicated, you be convicted of the offense, that your community supervision be revoked, that your punishment be assessed for that crime at 4 years confinement in prison, with you being required to pay the balance of your financial obligations, fines, court costs, reimbursement fees, restitution, In addition, the DA's office is asking the court to consider and dismiss some filed cases and unfiled cases. Filed case of a false alarm or report, unfiled cases of criminal trespass, criminal mischief, failure to ID. And you would receive 572 days credit towards your sentence for the time that you've spent in jail on this cause. Is that your understanding, Ms. Saunders?
Yes, Your Honor.
All right, then, Ms. Saunders, how do you plead to counts 1 through 5 as alleged? Are those counts true or not true?
True, Your Honor.
And are you pleading true to all these counts because what is alleged is in fact true?
Yes, Your Honor.
And has anybody threatened you, forced you, or made you feel like you had to plead true to any?
No, Your Honor.
All right, the court will accept the defendant's pleas of true to each count as alleged. Mr. Manning, any objection to the defendant's plea of true in evidence?
No objection as offered.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that, as part of the plea, there was restitution in one of the cases that we are, asking the court to take into consideration and dismiss. We have an estimate from, victim in the case. We're still trying to get more of an itemized, restitution amount. I don't know if the court would like to set a, kind of a follow-up hearing so that we can get that established and, set out in judgment form.
Anything further from the defense?
Judge, I don't anticipate the restitution to be much, based on my belief that there should be insurance coverage for the property damage. And so that all that would be left would be to pay the deductible. So we were fine with setting that off for a hearing at another time.
All right, then, based on the evidence before the court finds that Haley Delane Saunders has violated the terms and conditions of her community supervision. Court will follow the plea agreement today between the defendant and the state. The court adjudicates her guilt, convicts her of aggravated assault with a deadly weapon. The court revokes her community supervision, assesses punishment at 4 years confinement in prison, orders her to pay the balance of her financial obligations, including fine, court costs, reimbursement fees. Further, the court awards her 572 days credit towards her sentence for the time that she's already spent in jail on this cause. And the court dismisses those offenses outlined in the judgment under section 1245. The court will set Ms. Saunders for a hearing on March 27th to determine restitution. Ms. Saunders, in the meantime, you're going to be remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. The only thing that we need to be careful about is if the sheriff's office orders her a TDC ticket that she's not picked up prior to the 27th before she can have that restitution hearing. So y'all might want to work with the sheriff's office to find out how quickly TDC is picking people up because I've pronounced sentence today. Okay.
Yes, Judge.
All right, so Ms. Saunders, please step over to be fingerprinted and then we'll see you back on the 27th to determine restitution, if any.
Thank you, Your Honor.
You're welcome.
Judge, the only other person I have at this point in time, or issue I have at this point in time to take up is Mr. Hubbert. We had attempted to get his plea done, I guess, in absentia. And I just received the paperwork on his case today. So at this point, I don't see any need to have Mr. Hubbard's case call this afternoon, unless the court would like to make that announcement on the record.
Does he know that his case is not going to be done today?
I have not been able to speak to him since I was waiting to go talk to him with the paperwork, and obviously we didn't have that. So if we want to make him aware of that, we can do that. I think Ms. Abraham said he's set for 3.
Yeah, I would like to go ahead and call him so that he's aware of what's going on. If he knew prior to now that we weren't going to be having a hearing, but if he's under the impression that he's going to have a hearing today, then I want to go ahead and get him zoomed in and let's tell him what the issue is so he's aware.
Yes, Judge. I think that's, besides Mr. Rogers, that's all of my clients that I have prepared this time.
If, let me see on, let me pull up my email real quick. We may be able to go ahead and do Mr. Rogers then. I'm not seeing anything in my email, so I'll have to recall that case.
Okay, Judge, let me double check, make sure that everything's sent through. But we did complete that on the tablet earlier, maybe it didn't upload correctly, I'll check that. And
There might be one. Okay.
Ms. Ventura has received it. So there may be, maybe we may be waiting on the probation
Okay,
check marks.
I'll be looking for it. As soon as I see it, I'll call it back up.
Thank you, Judge.
Your Honor,
Good afternoon, Your Honor.
Mr. Lawhorn's ready on Mr. Schultz.
All right, Mr. Schulz, come on up. This is cause number CR 22-116, State of Texas versus Robert Michael Schulz on motion to revoke. Any announcements, Mr. Lawhorn?
Yes, Your Honor. We've reached an agreement for the court to consider with the state. We're present and ready to proceed.
All right.
Mr. Schultz will be pleading true to paragraphs 2 through 5, Your Honor, of the motion.
All right, Mr. Schulz, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Schulz, you appeared before this court on September 27th, 2022. You pled guilty to the offense of terroristic threat of a public servant. The court heard the evidence, followed a plea agreement that day, and the court assessed your punishment at 7 years confinement in the Texas Department of Criminal Justice. And pursuant to your plea agreement with the state, the court suspended that sentence and placed you on community supervision for a period of 7 years. In September of last year, the state filed its motion to revoke your community supervision, and they alleged 5 separate counts of violations. Have you had enough time to review that motion and the allegations with your attorney, Mr. Lawhorn?
Yes, sir.
And do you, are you satisfied with Mr. Lawhorn as your attorney and the work that he's done?
Yes, sir.
And do you understand everything that you've read and signed today, Mr. Schulz?
Yes, sir.
And Mr. Schulz, where you did sign, is that your true and correct signature?
Yes, sir.
All right, and Mr. Lawhorn, does your client waive the formal reading of the state's motion to revoke?
It does indeed, Your Honor. We have the motion in front of us and we've gone through a lot of verse.
All right. All right, Mr. Schulz, at this time, I'm going to ask you, how do you plead to counts 2, 3, 4, and 5, or counts 2 through 5, true or not true? And are you pleading true to counts 2 through 5 because the allegations are true?
Yes.
And Mr. Schulz, has anybody threatened you, forced you, or pressured you to plead true to anything in court today?
No, sir.
Did you say no?
No, no, sir.
Okay, then the court will accept the defendant's pleas of true to counts 2 through 5. Mr. Lawhorn, is there any objection to the admission of the defendant's waiver of rights and plea of true in evidence?
No objection, Your Honor.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Nothing from the defense at this time, Your Honor.
All right, the court finding that Mr. Schulz has violated the terms and conditions of his community supervision based on the evidence before the court. Court will follow the plea agreement today. The court hereby revokes the community supervision of Robert Michael Schulz. The court sentences him pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice. Court orders him to pay the balance of his financial obligations, including fines and court costs. And the court awards Mr. Schulz 92 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Schulz, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Good luck to you, sir.
Thank you, Your Honor.
You're welcome, sir.
May I be excused?
Yes, thank you, Mr. Lawhorn.
Thank you.
Sir.
Not possible.
And Ms. Abraham, I do have the plea agreement now on Mr. Rogers, if Mr. Manning's available.
Okay.
You want to go ahead? I think you're electronic, Mr. Manning is still signing some stuff. I'm ready on 2 pleas if you want to do those, or I can
That's fine. That's fine. Who are
wait
you
on
ready?
him. I don't want to throw you off your game.
No, it's okay.
Uh,
Who are you ready on?
Jason Bearden.
All right, Mr. This is cause number CR 21-276. I'm sorry, -278. Mr. Bearden, sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thanks, sir. You can lower your hand. All right, Mr. Bearden, you appeared before the court previously on July 21st of 2022. You pled guilty to possession of a controlled substance, third-degree felony offense. The court heard the evidence that day and followed the plea agreement that you had with the DA's office. And the court deferred a finding of guilt and placed you on 2 years community supervision. Court finds that your period of community supervision was also extended for an additional 1 year and 6 months. It was during your period of community supervision that the state filed its motion to adjudicate and revoke. Have you had enough time to review the counts alleged in that motion with your attorney, Mr. Schmidt?
Yes, Your Honor, I have.
And are you satisfied with Mr. Schmidt and the work he's done as your attorney?
The greatest attorney in Van Zandt, sir.
Okay, did he pay you to say that, sir?
Yes, sir, he did.
I like your honesty. All right, Mr. Bearden. All right, Mr. Schmidt, it's going to be hard to follow that, but do you believe that your client is competent today? And if so, have you explained to him his rights as they pertain to this motion to revoke?
Yes, sir. I have.
All right. I see here upon your plea of true, Mr. Bearden, the state's recommending that your guilt be adjudicated on that crime of possession of controlled substance, meaning that you would be convicted of that offense today. The agreement is that your community supervision would be revoked, that your punishment would be assessed under section 1244A, meaning that you would be convicted as a felon but punished as a misdemeanor, that you would receive 356 days punishment on that in the county jail, that you would receive credit for all 356 days of time served, and you would be ordered to pay the balance of your financial obligations, which at this time appears to be a reimbursement fee of about $1,100. Is that your understanding of the plea agreement, Mr. Bearden?
Yes, sir, that is correct.
All right, Mr. Schmidt, does he waive the reading of the state's motion to adjudicate, and is he pleading true to all counts?
Yes to both questions.
Okay, all right, Mr. Bearden, then how do you plead to counts 1 through 15 alleged in the motion? Are those counts true or not true?
True, sir.
Are you pleading true to each and every one of those counts because what is alleged is in fact true?
Yes, sir, I will agree with that.
All right, and Mr. Bearden, has anybody threatened you, forced you, or made you feel like you had to plead true to anything in court today?
No, sir, they have not.
All right, court will accept the defendant's pleas of true to each count as alleged. Any objection, Mr. Schmidt, to the admission of the defendant's waiver of rights of plea of true?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence and testimony before the court finds that Jason Kobe Bearden has violated the terms and conditions of his community supervision. The court, pursuant to the plea agreement, convicts him of possession of a controlled substance of penalty group 1 less than 1 gram, assesses his punishment under section 1244A of the Texas Penal Code at 356 days confinement in the Van Zandt County Jail. Court awards him credit towards his incarceration for 356 days of time already served. The court also orders him to pay the balance of his financial obligations. So, Mr. Bearden, when you are released, if you're not able to pay that $1,100 at once, you'll need to report to the district clerk's office and make arrangements to get that paid off. You understand?
Yes, sir.
All right, Mr. Bearden, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
Thank you, Your Honor.
You're welcome. Right, are you want Ms. Melissi or Mr. Piercefield?
Piercefield.
Mr. Piercefield, if you'll come on up, this is cause number CR 22-75, State of Texas versus John Daniel Piercefield. Mr. Piercefield, sir, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, now lower your hand. Mr. Piercefield, your name is John Daniel Piercefield, correct?
Yes, sir.
And sir, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you satisfied with Mr. Schmidt's work as your attorney?
Yes, sir.
Do you have any questions about your plea agreement or any of the paperwork that you signed today?
No, sir.
Where you have signed these documents, are you testifying that that's your true and correct signature?
Yes, sir.
All right, and Mr. Schmidt, is this a waiver of indictment and plea to an information today?
I believe it's a CR 22 indictment, Judge. The judgment shows information that I believe it should say indictment.
Okay, can you check on that, Mr.
Yes, sir.
Hartwell? And if it is in fact incorrect, we'll need to change the indictment to say, change the judgment to say indictment
Yes, sir.
rather than information. All right, Mr. Piercefield, you are charged with what appears to be, to it. A state jail felony offense of possession of controlled substance of penalty group 1 less than 1 gram. I see that the plea agreement today would entail you pleading guilty to that crime in exchange for the state's recommendation that your prosecution be continued under section 1244A, meaning that you would be convicted as a felon, but you would be punished as a misdemeanor. And the punishment range for a Class A misdemeanor is up to a maximum 365 days in the county jail and up to a $4,000 fine. Bless you. It's okay. I see that your agreement is upon your plea of guilty and prosecution pursuing as a misdemeanor punishment that you would be convicted of the offense, that you would be sentenced to 224 days confinement in the county jail, to which you would receive credit for time served for the time you've already been in jail. Further, you would be assessed a fine in the amount of $1,250, restitution of $180, court costs of $290, and reimbursement fees of $585. Is that your understanding, Mr. Piercefield, and what you're agreeing to?
Yes, sir.
All right, then, Mr. Piercefield, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Piercefield, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence being admitted?
No objection.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that it was in fact an indictment, and Mr. Hernandez has a corrected front page of that judgment for you.
So, Mr. Schmidt, they've corrected that. I'll attach it to the paperwork when he gets over here so that you can see that.
Judge, just for the record, I'm looking through my packet. And although we do not object to the stipulation of evidence, I don't believe that there is a printed. I don't have it in my hand. And it is not signed by myself or the defendant.
Your Honor, I will work on getting one over to them. In the meantime, the court will bear with me for just one moment.
Do you have one on your computer?
I don't yet, Your Honor. I can give an oral motion here in just a second. It's just an older case, so getting the
It's no red.
and Your Honor, I can give an oral recitation of the facts.
All right, go ahead.
On or about November 24th of 2021, Mr. Piercefield and a passenger, Miss Pettis, were stopped by Van PD for an expired registration. During the traffic stop, Miss Pettis informed the officer that there were drugs in the vehicle and told the officer that it was methamphetamine. She showed the officer the bag and that it was in the gear shift area. And so evidence would show that both Miss Pettis and Mr. Piercefield knew about that. It was there. It was being in the gear shift. They would both have access to it and control over it. And the DPS labs confirmed it to be 0.41 grams of methamphetamine.
Any objections to that recitation as the stipulation of evidence, Mr. Schmidt?
No objection.
All right. Court, then having considered the evidence, finds that there is sufficient evidence to convict Mr. Piercefield of this offense. Court will follow the plea agreement today. Court convicts John Daniel Piercefield of possession of a controlled substance in penalty group 1 less than 1 gram. Court assesses his punishment under section 1244A of the Texas Penal Code at 224 days confinement in the county jail. Court issues him credit for time served. orders him to pay a $1,250 fine, restitution in the amount of $180, court costs in the amount of $290, and reimbursement fees in the amount of $585. Mr. Piercefield, once you are released from custody, if you're not able to pay off your fines, restitution, all of that, then you'll need to report to the courthouse and go to the district clerk's office and talk to them about setting up a payment plan so that you can discharge this. Failure to do so could result in the court issuing a warrant for your failure to pay those fees, okay? All right, you're hereby
Yes, sir.
remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. Mr. Manning, are you ready on Mr. Rogers?
Yes, Judge.
All right, Mr. Rogers, this is cause number CR 25-26. State of Texas versus Joshua Paul Rogers. Sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. All right, Mr. Rogers, let's see here. It appears that you were indicted with a third-degree felony offense of assault of a family or household member by impeding breath or circulation, a third-degree felony. A third-degree felony does carry a range of punishment. Let's see, hang on.
Judge, they've alleged an enhancement.
Okay, that's why it says second degree.
Yes, Judge.
Right, so Mr. Rogers, you are charged by indictment with assault of a family or household member by impeding breath or circulation, normally a third-degree felony. However, the state has alleged an enhancement paragraph in your indictment, which, if that information is found to be true, would elevate your degree of offense to a second-degree felony, which has a different range of punishment of not less than 2 years in prison up to a maximum 20 years in prison, and a possible fine not to exceed $10,000. Mr. Rogers, are you pleased and satisfied with Mr. Manning and the work that he's done as your attorney?
Yes, sir, I am.
Do you understand everything you've reviewed and signed today in court?
Yes, Your Honor.
And where you have signed that's your true and correct signature, correct?
It is, yes, sir.
Mr. Manning, do you believe Mr. Rogers to be competent to enter into this agreement? If so, that he is doing so voluntarily and intentionally and knowingly, and that he also understands the advantages and disadvantages of a deferred adjudication plea?
Judge, I have explained the advantages and disadvantages of a deferred adjudication. I do believe he's entering into this plea intentionally, knowingly, and voluntarily, and he is competent based on my interactions with him as well as pursuit of defenses in his case.
Thank you, Mr. Manning. All right, Mr. Rogers, I see that the plea agreement in this case, upon your plea of guilty to that offense, the DA's office is recommending that the court consider the evidence but not convict you today. Rather, they're recommending that you be placed on 5 years community supervision with a $1,000 fine, a batterer's intervention program as a condition of your community supervision. In addition, part of the agreement is a 10-year protective order for the alleged victim in this case. In addition to that, you would be assessed court costs of $290, reimbursement fees of $520. Is that your understanding of the plea agreement as well?
It is, yes, sir.
All right, so let me ask you, Mr. Rogers, How do you plead to assault of a family or household member by impeding breath or circulation?
Guilty.
And how do you plead to the enhancement paragraph contained in the indictment? Is that allegation true or not true?
It's true, sir.
All right. Mr. Manning, do you have any objection to the stipulation of evidence in this offense?
Objection as offered.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance with victim contact. Victim at first was hesitant to accept this plea. However, she expressed that she wanted Mr. Rogers to have access to services for any kind of help to be successful. Wasn't necessarily looking for prison. When we explained that protective order was a possibility, she was happier with that. And so she remains hesitant, but accepting of the plea.
All right, thank you, Mr. Hartwell. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, the court will consider the evidence. All right, the court, having considered the evidence, finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement and recommendation of the DA's office today. Court hereby also finds the enhancement paragraph alleged to be true. Court will defer a finding of guilt on the second-degree felony offense of assault of a family or household member by impeding breath or circulation. The court, deferring a finding of guilt, places Mr. Rogers on 5 years community supervision, orders him to pay a $1,000 fine, $290 court cost, and $520 in reimbursement fees. Further, the court orders as a special condition of community supervision that he attend, complete the batterers intervention program, and the court will approve, as part of the agreement, a 10-year protective order for the victim in the case. Mr. Rogers, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence, and have you step over to be fingerprinted.
Thank you, sir.
And Judge, at this point in time, I don't believe we have a fingerprint. We on the electronic plea sheet, we printed one out. We executed one, but we don't have a physical copy of that at this time.
Would you ask?
Do you need one? Are you saying that you need one emailed over?
Ms. Patty asked if you would email one over, she could print that out. It could be emailed to Ms. Ventura.
Ms. Abraham, do you know where that's stored at on the drive?
Yes, where it's stored on the drive.
On on my desktop, I think. But Mr. Hartwell has one.
Your Honor, I can get one over to
Okay,
them.
Mr. Hartwell said he'll email one.
Thank you.
Training, you ready on anyone else or just the
Yes,
three?
Judge.
Who are you ready on?
Mr. Justin Guyton.
Right, this is State of Texas versus Justin Jamel Guyton, CR 24-54 pretrial. Go ahead, Mr. Manning.
Judge, we are going to be filing a contested pretrial matter on a motion to suppress. I spoke with Mr. Guyton recently, but I was unable to get a docket filed before the deadline for court today. So I request that we reset this case for the contested docket, and I will, as an officer of the court, make sure that it is filed 7 days or 10 days prior to that contested hearing.
All right, court will set Mr. Guyton for evidentiary hearing on March 27th at 1:30.
Judge, next ready, Mr. Danforth.
State of Texas versus Christopher Wade Danforth, CR 24-303 and 304 on pretrial.
Yes, Judge, at this point in time, I have not received discovery for CR 24-303. So I request that pretrial be reset. Additionally, Judge, we're also waiting an offer to resolve both of Mr. Danforth's cases.
Mr. Hernandez, do you know, has the electronic discovery been turned on for Mr. Manning and CR 24-303?
I can take a quick look, Your Honor. Thank you.
Mr. Manning, are you saying it's the entire discovery portal or is it just electronic discovery?
Sorry, Judge.
Are you looking for a disc or you're saying you don't have any discovery?
Any discovery for that case? It's not even attached to my name.
Okay. Mr. Hernandez is looking right now.
Thank you, Judge.
And while Mr. Hernandez is doing that, the court will set Mr. Danforth for pretrial in each case on April 10th at 1:30. But let's give him a moment so we can see if you're going to get connected.
That's correct, Your Honor. Case number CR 24-304 does not believe that we provided discovery. Make sure that those things are placed in the portal form as soon as possible.
303 and 304.
303 was checked off as having been set up, but we'll double check both cases.
Okay. Did you hear that, Mr. Manning?
I did not, Judge.
Say that again, Mr.
Yes, sir. It appears that case CR 24-304 has not been made available through the portal for discovery. We will do that this afternoon. I will also double check on CR 24-303. Those have been checked off and I believe should be in the portal.
Okay. All I know, Judge, is I had one, not the other.
Okay. All right,
So-
Mr. Hernandez is going to double check that, and should you have any issues, just contact him, and we'll see y'all back on April 10th.
Thank you, Judge.
Ready on anyone else?
Yes, Judge, ready on Mr. Michael Chitty.
Michael Chitty, cause numbers CR 22-267 and CR 22-308. Court finds that Mr. Chitty, having requested court-appointed counsel on motions to vote, finds him to be indigent. The court has appointed the Honorable Jonathan Manning as counsel. Mr. Manning, I will set this for the next motion to revoke docket, which will be March 27th at 1:30.
Thank you, Judge.
Who's next?
Judge, if we may call Miss Hannah Hampton.
Anna Marie Hampton, CR 20-390. Motion to revoke.
Yes, Judge. Judge, Miss Hampton, I just learned late yesterday, have been taken in custody on the court's warrant, based off of the motion to withdraw, motion of forfeit bond. I learned, like I said, late yesterday that she was in custody here in Van Zandt County Jail. I'd asked that we sit in the March 27th docket for, give me an opportunity to speak to my client and look at how we're going to resolve this case.
All right, court sets Ms. Hampton for the next contested docket, March 27th at 1:30.
Thank you, Judge.
Who's next, Mr. Manning?
Judge, if we would like to go ahead and call Mr. Hampton's, Mr. Park's case. He was set for today, but I believe we were unable to get him here from Hunt County.
Say Hart.
Mr. Parks.
Okay, sorry, I heard Hart. All right, this is cause number CR 22-192, State of Texas versus Joseph Leon Parks. Mr. Parks is incarcerated in Hunt County. Do we know why the bench warrant was denied? Is it because he's waiting for TDC?
Judge, I believe Ms. Abraham had received several different stories as to why he was unable to be transported, so I'm not sure which one of those was the results, but at one time there was a question as to whether or not he had a TDC hold, but I don't know what the final resolution was on that.
We set him today for status. Do we know what we were doing status of other cases in other counties or?
Judge, I believe he has a motion to adjudicate.
Okay. All right, court will reset Mr. Parks for March 27th and we'll, I guess, try a bench warrant again. See what happens.
Thank you, Judge.
Your Honor, it says Hunt County advised that the subject had already been indicted and would not release him to our custody. It's what the transport officer wrote on the bench warrant.
That he had been indicted.
What it-
Okay. He's already been indicted here too. That's what's interesting. I think our indictment was first, so I'll have to call over there and figure out why my bench warrant's being dishonored.
Judge, if I may, I have a couple things to talk with my remaining folks. If I may have just a couple minutes. I believe Mr. Schmidt's ready to do his resets.
Yes, sir.
Thank you, Judge.
Mr. Schmidt, who would you like to call?
Marie Melissi.
Maria Edith Melissi, CR 15-152. All right, Ms. Melissi, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand.
And Judge, prior to coming today, Ms. Melissi had retained Nolan White. Nolan White had signed or submitted a motion to substitute counsel. I believe that's still pending. Ms. Melissi has asked that I argue to the court to allow her to retain Mr. White and that she be granted an additional 30-day extension to her motion to adjudicate, to give her an opportunity to meet with him and have him work on her case.
Ms. Melissi, do you have the financial ability to reimburse Van Zandt County today for all of the money that it's having to pay Mr. Schmidt to represent you? Because you asked the court to appoint you an attorney. I allowed you in October 31st, we had a hearing and you wanted to hire an attorney and I gave you 30 days and you didn't do it. And then you asked the court to appoint you an attorney and I appointed Mr. Schmidt on December 3rd of 2024. And then I set you for another 60 days out. And then we reset that hearing on January 27th to today. So you've had 90 days to hire an attorney. And now you have hired an attorney the day before we're supposed to resolve your case. So I want to know, are you able to reimburse Van Zandt County today for $500 for the money that we have to pay Mr. Schmidt for all the work that he's done for you that you've asked him to do?
Okay.
You can pay $500 today?
Yes, sir. Probably. Yes.
Yes, or probably, or what?
Thank you. More than likely, yes.
I'm gonna need a yes or a no. I mean, you either know
Yes.
you can.
Yes, sir.
Ms. Melissi, why did you wait 90 days to do this? And why are you doing this less than 24 hours for your court hearing?
Got all the money together for it. And I had already talked to Nolan and I told him, do I need to tell my lawyer? And he said that he was gonna get it handled and message or email him.
All right, and so Mr. Schmidt, your position is what? You want the court to,
Judge, my position is that Ms. Melissi, if she wants to retain Mr. White, then she should be allowed to do that. I have no objection to that. It's as her attorney right now, it's my job to advocate for her and ask the court grant her the time that she needs to allow Mr. White to take over the case and see what kind of efforts he can make on her behalf. Other than that, I have no position.
what about the state? Does the state have a position?
Your Honor, I believe that Ms. Melissi should have the right to hire I'm sorry, my video's turned off. I believe she should have the right to hire the attorney of her choosing. However, the timing is frustrating, Your Honor. If the court were to grant the substitution, I believe Mr. White is due back on March 27th. So I'd ask for it to be set that day. But Your Honor, I couldn't guarantee that the same offer would be extended at that point. The timing is frustrating for the state.
Ms. Abraham, do we know, is Mr. White going to be back and able to have a contested hearing on March 27th?
Your Honor, I believe, his date back was supposed to be March the 25th, so. I mean, that's what we've set amongst his far was March 25th.
All right, so Ms. Melissi, if I grant your request today, you understand that the DA's office has indicated they may not offer the same offer to you again. You understand? And if I grant this and they decide to pull that offer, there's nothing really you can do about that. You understand that?
Yes, sir.
All right, so what I'm gonna do, Ms. Melissi, I'm gonna grant your request. I'm gonna reset it to March 27th, and that's gonna be your very last court date. There's gonna be no continuances. There's gonna be no resets. And I'm gonna order you to reimburse Van Zandt County. Today is the 20th. I want you to have $500 paid to the pretrial release department for your attorney fees. Actually, until you're paid to the probation department for your attorney fees in this case. And I want that paid before tomorrow at noon. They close at noon. So it must be paid tomorrow. If it's not paid tomorrow by noon, then the court's going to consider revoking your bail and just putting you in jail until you're here. You understand?
Do it cashier's check or just come to the probation office?
The probation officers that are over there, they'll tell you how they want it.
Yes, sir.
Whatever I tell you may not be right, so I asked them how they want it. So sign your notice of setting. I will grant Mr. Wyatt's motion to substitute. I will reset you to March 27th.
Thank you.
Mr. Schmidt,
Yes, sir.
who would you like next?
Michael Whitten.
Mr. Whitten, if you'll come forward. All right, this is cause number CR 24-9, State of Texas versus Michael Joseph Whitten. Court has found Mr. Whitten to be indigent and has appointed Richard Schmidt as counsel for Mr. Whitten. Mr. Schmidt, do you want me to reset this to the March 27th date so you have more time to work on the case?
Yes, sir, please.
All right, court sets this case for hearing on the motion to March 27th at 1:30.
Judge, I was appointed Jacob Myers as well. I think Ms. Abraham has indicated that we're not gonna have him. I presume the court will set him for the,
When the 3 o'clock person came, so I don't know.
oh, they bring us one in 3. Okay, well, we'll recall him then, Judge. I'm ready on Robert Wales.
Okay, Mr. Wells, come on up. This is cause number CR 17-266, State of Texas versus Robert Michael Wells. Go ahead, Mr. Schmidt.
Judge, we are prepared to enter a plea on the state's motion to adjudicate. I have the documents in front of me.
I don't believe I have any of that paperwork. Do you want to cite the terms for me?
Yes, sir. Upon a plea of true, the state was recommending that the defendant's guilt be adjudicated as community supervision be revoked and that he be sentenced to 2 years in the Texas Department of Criminal Justice Institution Division in order to pay the balance of his financial obligations. At this time, those include $621.52 in fines, $70 in reimbursement fees. In addition, he is to be awarded 730 days credit time towards that sentence.
And I'm sorry to interrupt, Mr. Schmidt, when I changed the date, I didn't update the credit time. The credit time, so Your Honor, the papers were prepared back in early January originally. And so all I did today was correct the date to today. I didn't even think about the credit time, so I think we'll have to update that as well, to account from January 7th to today.
Obviously, if it's more than 730, we're happy with that.
All right, so how much time is that?
I believe 44 days, Your Honor.
So you're gonna more time. So that's what he's saying is that the credit time hasn't been taken for the time it's been in custody until today.
Mr. Hartwell said he believes the correct credit time would be 774 days.
Sounds right.
So we'll need to get the judgment modified to reflect 774
Yes, sir.
credit time. Give me a second. Pull this case up.
I'll drop it.
And Your Honor, if my math is correct, I believe this will essentially be a time served. At 774 days, we're past 2 years.
Mr. Schmidt, do you have a copy of the motion to revoke there? It's not scanned into the clerk's case, so I can't even see what the motion to revoke says.
I do not have a paper copy. I have an electronic copy that I could pull up for you, but basically we're playing true to counts. 1, 2, 3, 4, 5, 6, 7. I believe there's 7 counts in the state's motion. There's the formal reading of that. Playing true to the totality.
The underlying offense is a third-degree felony offense of theft of property, 20K to 100K.
Yes, sir.
And Your Honor, I've just printed out a copy of the amended MTL. Grab it and bring it
Oh,
to you.
please, that would help. All right, Mr. Wells, you'll raise your right hand. I want to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your
Yes,
hand.
sir.
All right, Mr. Wells, you appeared before the court on June 29th of 2017. You pled guilty to the third-degree felony offense of theft of property greater than $20,000, less than $100,000. Court heard the evidence, found that there was enough evidence to convict you of this offense. However, the court followed a plea agreement on that date and deferred a finding of guilt, placed you on community supervision for 10 years. Court also ordered you to pay a $750 fine. It was during your period of community supervision that the state filed an amended motion to adjudicate and revoke. And in that motion, they alleged 7 separate counts of violations. Have you had enough time to review the allegations against you with your attorney, Mr. Schmidt?
Yes, sir.
Are you satisfied with Mr. Schmidt and the work that he's done for you?
Yes, sir.
Do you have any questions about the plea or the paperwork or anything else?
No, sir.
All right, and Mr. Schmidt, having already indicated that you're going to waive the formal reading of the motion to adjudicate and enter pleas are true to all 7 counts, Mr. Schmidt, do you believe Mr. Wells to be competent to enter into this agreement?
I do.
That he's doing so intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Wells, how do you plead to counts 1 through 7 as alleged? Are those true or not true?
Sure.
And are you pleading true to all 7 counts because all 7 counts are in fact true?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead true to any count?
No, sir.
Court does accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of true?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir, just that on the front page of the judgment, I did mark out the credit time, so that front page will need to be replaced. I just want to remind everybody.
Yes, sir, and Mr. Hartwell's already printed it out here, and I do have it, and it'll show that credit time down there.
Yes, sir, thank you.
74 days. All right, based on the evidence before the court finds that Robert Michael Wells, having violated the terms and conditions of his community supervision, the court finds all 7 counts of alleged violations to be true. Court follows the plea agreement today. Court adjudicates Mr. Wells' guilt, convicts him of theft of property greater than $20,000, less than $100,000. Sentences him to 2 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 774 days credit for the time that he has spent in jail on this cause. Mr. Wells, when you are released, and I'm not sure what the sheriff's office will have to do, they'll probably have to contact TDC to determine whether or not they're to hold you, or if TDC is going to instruct them to release you based on your credit time. That'll be up to TDC. Once you are released, you'll need to report to the courthouse to pay off any remainder of your fines and reimbursement fees, okay? All right, Mr. Wells, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of. I'm gonna have you step over to be fingerprinted.
Yep.
This tape.
Yes, Your Honor.
All right, I do see that I have a couple people. I've got Dr. Reddy in the Zoom waiting room. I've got Big Spring State Hospital. I've also got Henderson County. Who I don't have is Mr. Lowe.
Your Honor, Mr. Lowe is here. I saw him out in the hallway. I don't know if perhaps the.
Yeah, let him in.
Yes, sir.
You want to go ahead and do Harrison County, so you can go to the courthouse?
That's fine. I can receive the remainder of mine.
You want to go ahead and do the resets from Henderson County?
That's fine.
I had asked if they would bring Myers. I'm not sure. I did not get a response, so I don't know if we have Myers or if we just have Mr. Hubbert.
Find out. All right, can you see and hear me okay?
Yes, sir.
All right, I'm sorry, I don't know your name. Are you Mr. Hubbard or Mr. Myers?
Hubbard.
Hubbard, all right. Mr. Hubbard, this is cause number CR 24-75, State of Texas versus Timothy Wade Hubbard. We're set for docket call today. Mr. Manning, go ahead.
Judge, as we announced last week, I was going to attempt to go down to Henderson County and get a plea and abstention done. We were unable to receive the paperwork timely. I don't know if that was a miscommunication on my part or at the DA's office, but unfortunately, we did not have the paperwork to go over. We'll need to reset Mr. Hubbard. My concern at this point in time, Judge, is that he is likely to catch chain before we are able to get his plea done at this point in time. So I'll defer to what the court's preferences on Mr. Hubbard's case.
Let me look at my calendar. We might make an adjustment. Mr. Manning, do you have the paperwork available now? Or are you still waiting on the paperwork?
Judge, I have a paper copy of the paperwork that was dated for today.
What if it's not a typical day, but I can work it in. What if we did next Tuesday, the 25th at 9 a.m.? Do you think that you could get over to see Mr. Hubbard, do the plea and go over the plea paper with him? And then we can zoom him in and he can stay in Henderson County custody.
Judge, at this time, I have a client meeting at 9 o'clock on Tuesday morning. I can see about rearranging it, but I do have someone coming from out of town to go over discovery at that time.
How long do you think that would take?
Approximately an hour.
What if we set it for 11 o'clock?
That could work.
All right, let's set Mr. Hubbard then for plea on Tuesday, the 25th at 11 o'clock.
And Judge, since it will be a true plea and abstention, I don't know if we need that documented on the judgment anywhere, or if the waiver of appearance that we normally use would suffice.
Well, my understanding wasn't, it wasn't going to be a plea in absentia. It was just going to be, you were going to get the paperwork signed, getting fingerprinted over there, and then we were going to do the plea on Zoom that day. So he would still be present in court, just on Zoom with a waiver of in-person hearing.
Okay, Judge.
Did I misunderstand that? You were one?
I think that's what we're gonna do when we had the electronic, when we were going to attempt to do it electronically. I just didn't know if having a physical judgment, if that's gonna change anything, chain of custody wise, or.
I think the only thing we needed to obtain was the finger, and we could have Henderson County, we can email them the fingerprint document. But a true plea in absentia would mean without the defendant being present in the hearing. And the only way to do that on a felony is to basically have have the defendant do all of the admonishments on a court of record where they're at. So they basically got to have a hearing in Henderson County to not appear on a judgment here in Van Zandt. So what I thought we were going to do was just get the paperwork, get the electronic paperwork together, and that you were going to go over that with Mr. Hubbard, either online or in person, and have him sign that electronically. And then we would have the Zoom hearing on Tuesday. He just wouldn't be brought to Van Zandt, and we would ask Henderson to get us a fingerprint for the filing. If that's the way that we're going to do it, I think that works.
Well, I'll see if we can get that wrapped up between now and Tuesday at 11.
Do you think that gives you enough time though to go to Henderson County and go over the paperwork with him?
Sorry, Judge, you're breaking up.
I said, do you think that gives you enough time to go over to Henderson County? That's only 2 working days. That's tomorrow and Monday. If we need to move it to Thursday of next week, I mean, I had a jury trial canceled, so I have some flexibility. And I'm just trying to accommodate so that we can catch Mr. Hubbard, so we don't have to send our sheriff's office down to TDCJ.
Right, Judge. Yeah, let's try Tuesday at 11.
Like I said, we can do Thursday as well. If you need more time.
What time on Thursday?
Yeah, you tell me.
I'm in Kaufman County in the afternoon and I have discovery meeting in the morning, but I might be able to do it. I might be able to do it at 11.
You gonna try it with 11 on Thursday be better?
Yes, Judge.
All right, well, let's do that. Let's set Mr. Hubbard then for the 27th at 11. So, Mr. Hubbard, do you understand what we're talking about?
Yes, I have one question.
Yes, sir. Go ahead.
Is this gonna be ran concurrent?
Yes, Judge. Yes, it is.
Okay. All right, I just wanted to make sure.
And Judge, I did ask if the state would be willing to 12:45 this case, as his case down in Henderson County would eat up or subsume any and all time. Mr. Hubbard got 10 years out of Henderson County, and the state's offering, I think, 2 or 3 in this particular case. So maybe if we're unable to get it done next Thursday, maybe we reconsider that if that's an option.
All right, so Mr. Hubbard, Mr. Manning's gonna try to come and see you over in Henderson County to go over the paperwork once he has that sorted. And then I will have you scheduled to appear via Zoom again in my next Thursday at 11 a.m. and we'll try to get you pled out before TDCJ picks you up. If between now and then TDCJ picks you up, then I'll just have to figure out where you land and they come and bench warrant you and drive you back up here.
All right. And when I was there last time, my lawyer told me, I think he said he works in Kaufman County. He does Kaufman County too?
Are you talking about Mr.
I'm sorry?
Are you talking
Yeah,
about
yes, sir.
Yes, I do.
I got a motion to revoke state jail felony out of there. I don't know if you could see about anything or, get something moving on that, but I got a motion to revoke on a state jail felony, 2 years deferred probation. I don't know if you could.
Yeah, I'll speak to the court coordinator over there and the indigent defense coordinator. And if you qualified here, you should qualify there. And I'll see if we can get your cases dropped up.
Okay, thank you very much.
All right, Mr. Hubbard, we'll see you next week then at 11 o'clock on Thursday.
Yes, sir. Thank you very much.
All right, and if you can do me a favor before the jail staff shuts the computer down, if you could ask them if I could talk to them.
Yeah, let me hit the button real quick. They're not in here, but let me hit the button and ask them real
All right,
quick.
yes, thank you.
Judge, while we're doing that, can we reset Mr. Hagan's case?
Sure.
Yes, could you let Ms. Morrison know that the lawyer from the judge from Van Zandt County wants to speak to her and he's on video visit right now.
Okay, I'll let her know. Thank you.
Thank you.
Thank you, Mr. Hubbard. Appreciate it.
All right, thank you. I'm waiting for her to come in now.
Yes, sir.
All right.
All right, Mr. Hagan, this is cause number CR 22-180, State of Texas versus Jeffrey Ray Hagan on motion to revoke. Any announcements, Mr. Manning?
Judge, at this point in time, we have not reached an agreement. I request for a final setting on evidentiary contested motion to revoke on March 27th.
Any objection from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Hagan for a final hearing on the motion to revoke March 27th at 1:30.
Thank you, Judge.
Do you also have Mr. Loden in there as well, Mr. Manning?
Judge, we've reached an agreement on Mr. Loden's case to withdraw and extend.
And Mr. Manning, that email just came through.
Okay. But I will not need to be present physically for that paperwork. There's nothing for me to sign. So if you'd like, if we want, we'll try.
Hang on, Mr.
Hi.
Hello, thank you for making Mr. Hubbard available today. I was gonna ask you, I think we had sent over a request. You have another inmate by the name of Jacob Myers. I don't know if you got email. Is there any way that we could have Mr. Myers for a quick hearing as well?
You bet. I can get him up here.
All right, thank you. It's Jacob Wyatt Myers.
Okay. Is he done then?
Mr. Hubbard's done, yes, sir. Yes,
I
ma'am.
will be right back.
All right, thank you.
Uh-huh.
All right, Mr. Manning, sorry about that. All right, you were saying on Mr. Loden that there was an agreement to withdraw?
Yes, Judge.
All right, let me get on the record so you can tell me what that is.
And Judge, once we get on the record, I'll explain.
Okay, we're on the record, cause number CR 19-23, State versus Justin Edward Lee Loden, motion to revoke. Go ahead, Mr. Manning.
Yes, Judge. Mr. Loden was reaching the end of his probation term. He owed some fines, court costs, and probation fees. Mr. Loden was having difficulty with transportation, so he missed one or two of his finals. He stayed in communication not only with Henderson County, where he was reporting, but also with Van Zandt County. Since he's been incarcerated, he has received some checks that will be able to pay the remainder of his balance in both his fines and court costs, as well as his probation fees. And so the state has agreed, along with the probation department, to extend him for a period of 6 months for payment, which I believe he should be able to get done sooner than that, based on the checks that have been provided. Proof of checks have been provided by his family.
Okay.
Yes, Your Honor.
All right, and probation's supportive and in agreement?
Judge, probation sent an email on Mr. Loden's behalf explaining to him the steps that he's made since he came back from safety and how he's turned around from that point in time.
All right, so it's a motion to withdraw and continue?
Withdraw, I believe it extends 6 months due to him being at the end of his probationary period.
All right, Mr. Loden, if you'll raise your right hand, I'm going to place you under oath. Mr. Loden, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Loden, is it your desire to have your probationary period extended for an additional 6 months?
Yes, sir. It'd give me plenty of time to go ahead and finish paying everything off.
And you believe that if the court grants that, that would put you in a position to where you could be successful on your community supervision?
Yes, sir. Yes, sir, I do.
And has anyone threatened, forced, or pressured you to make that decision today?
No, sir.
All right, then the court will grant the state's motion to withdraw. The court will modify the conditions of community supervision to extend Mr. Loden an additional 6 months. So, Mr. Loden, I will get that form signed and you can meet with the probation officers about more information.
Yes, sir. Thank you.
You're welcome.
Judge, I believe that concludes my business here. May I be excused to come to the courthouse?
Yes, sir. Thank you. All right, Mr. Abraham, is that everyone that's there in the Van Zandt County Jail?
Except for waiting on Mr. Myers, and then Big Spring called and said that they are ready.
Yeah, they're in the waiting room and I've sent them a message. It'll be just a few moments. Let's wait and see if Mr. Myers pokes his head in and then we'll move on to
At the empty room.
Mr. Gerard.
So I was gonna- Never mind. I'm gonna figure that out. So all these are good. What I do now is.
Oh, y'all can go back now. I mean, it'll be an hour or so.
Yes, ma'am. Thank you. Polish and Terry.
You want to send Lisa a piece?
And Your Honor, while we're waiting, we've not received Lisa Pieces' judgment. I think we were getting a fingerprint or something while we were here. Is that correct?
Your Honor, they have been, completed. Ms. Abney sent them to me for review. There were a couple of corrections, so those should be, forthcoming. It's taken a little while just, between, docket and trying to review that, but those should be, forthcoming pretty quick.
Okay, thank you.
All right. You fancy friend.
All right, we're back on.
Mr. Myers, can you see and hear me okay?
Yes, sir.
All right, you're Jacob Wyatt Myers, correct?
Yes, sir.
All right, Mr. Myers, we're in court today here in Van Zant County on your motion to revoke, and your attorney, Mr. Schmidt, is here. Can you see Mr. Schmidt as well?
Yes.
All right, Mr. Schmidt, we're set today in CR 23-30, State versus Jacob Wyatt Myers on the motion to revoke. I believe that you'd already indicated to the court that you needed more time, and we're asking the court to reset it to March 27th. Is that correct?
Yes, sir. I spoke to Mr. Myers last week, but I have not, as you know, I was appointed this morning. I haven't received the motion. So, yeah. The
All right.
3.7, whatever.
So, Mr. Myers, what we're going to do is I'm going to reset your case to March 27th. And if we need to have a hearing over here, then I'll have you bench warranted back to Van Zant. Otherwise, Mr. Schmidt may be in contact. And if an agreement's worked out, you may be able to sign your agreement, when you're over in Henderson County. We just wanted to let you know kind of what's going on in your case.
Okay,
And I
thank
think
you.
he's being held there on our motion. Is that, were you charged with anything in Henderson County? Jacob?
No, I'm just being held at, I guess, a contract hold is what they told me.
I see. Thank you.
Okay, so we may have you picked up and housed in Van Zant County for your next hearing, okay?
Okay,
All right, thank you, Mr. Wyatt, or I'm sorry.
thank y'all.
Have a good day.
All right, thank y'all.
You're welcome. All right, Ms. Tabraham, does that conclude everyone that's in custody that's going to be appearing via Zoom today? So Mr. Manning will be coming back over with a contested hearing on Mr. Parker, correct?
Yes, he's already on his way back. I guess we will stay till we get Miss Pieces.
Yes.
Okay, we just got it.
Okay.
Okay, we'll be back shortly.
All right, let me bring in Big Springs Hospital and Dr. Reddy. How you doing, Mr. Lowe? Did I hear you jiggling on the door trying to get in? I told everybody to be quiet. I said. All right, let's bring in, let me do this. Let me turn on this TV. Taking my laptop. Do you have a laptop with you or is that okay?
It's notepad, so I think I can get my phone.
Can you? They took my laptop, otherwise I would.
I reckon this is.
I'll tell you what I'll do. Good afternoon, Dr. Reddy. Can you see and hear me okay? My name is Judge Chris Martin.
Yes, sir. Good afternoon.
Good afternoon. I appreciate your patience. Sorry, we were running a little bit late with some of our other inmates, so sorry to impose on your time. And let me see if I can unmute. All right, Robert, are you able to unmute that device where you're at?
Yes, sir.
All right, excellent. So Robert, can you see and hear me okay?
Yes, sir.
All right, well, you're looking well. How are you doing?
Doing good. How you doing?
Oh, I'm doing fine. I'm doing fine. Thank you for asking. Can you see your attorney, Mr. Lowe?
Yes, sir. Yes, sir, I can.
All right, can you see the district attorney, Ms. Curry?
Yes, I just saw her. She was on. There she is.
Okay, good.
Yes,
All
yes.
right, and can you also see Dr. Reddy?
Yes, sir.
Excellent, okay. All right, I'm gonna call this hearing. This is cause number CR 22-67, State of Texas versus Robert Gerard. And today we are having a hearing on the extended mental health services for Mr. Gerard after the court found him to be not guilty by the reason of insanity. Ms. Curry, are you ready to proceed?
We are, Your Honor.
All right, and Mr. Lowe, are you ready to proceed?
Yes, Your Honor.
All right, go ahead, Ms. Curry.
Thank you, Judge. We'd call Dr. Reddy, please.
All right, Dr. Reddy, I'm gonna, you've been called as a witness. If you'll raise your right hand, sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I swear.
All right, thank you, sir. You lower your hand. During your testimony, Dr. Reddy, if you'll just speak up loudly and clearly so I can ensure that I can hear you, all parties can hear you, and my court reporter can take down what you have to say. Go ahead, Ms. Curry.
Thank you, Judge. Dr. Reddy, would you state your full name for us and give us your professional background, please?
Yes, ma'am. My full name is Srinivasa Reddy Danti Reddy. I am one of the staff psychiatrists at Big Spring State Hospital. I'm licensed to practice medicine in the state of Texas in the specialty of psychiatry. I'm a board certified physician, and I completed my medical school as well as 4 years of psychiatric residency training, which makes me eligible to practice psychiatry in the state of Texas.
And do you meet the requirements in the criminal code for doing a psychiatric evaluation?
Yes.
How long have you been employed there at Big Spring?
This is my 6th year at Big Spring State Hospital.
And do you commonly, as a part of your job duties there at Big Spring, do you commonly see people who have been committed because they were found not guilty by reason of insanity?
Yes, ma'am.
Is that a large part of what you do?
Not a large part. I would say a few patients for sure, like 10 to 20% of my patients are NGRI committed patients.
And what are the majority of the rest of your patients? Are they pretrial?
Yes, competency to stand trial commitments mostly.
So is it fair to say that you are familiar with the sections of the criminal code that deal with people who have been committed based on a finding of NGRI?
Yes.
And have you been treating and or evaluating the patient today, Robert Gerard?
Yes.
Now, I see that he's only been at your facility since January the 27th. Is that correct?
Yes, that is correct.
So you haven't quite had a full month with him yet.
That is correct.
In the time period that you have had you had the opportunity to observe and determine whether or not you believe that Mr. Gerard has a serious mental illness?
Yes, I have enough time to understand Mr. Gerard's mental illness, and I reviewed the records before his admission to our facility, and
And what mental illness do you believe that he suffers from?
Clinical opinion, he's suffering with schizophrenia.
As a result of his schizophrenia, do you feel like at this point in time Mr. Gerard is a danger to himself or to the community if he were released?
There are no imminent signs of danger to self or others at this point of time.
And normally when a person in your facility for NGRI, when they are treated to the point that they are no longer a danger to themselves or the community, they're eligible for release. Is that correct?
Normally a civil patient means, who doesn't have a commitment like NGRI commitment is normally for discharge from hospital, and we started looking for a placement for the patient.
When you discharge a person under those circumstances, do you just open the front door and let them out, or is there a lot more preparation that goes into it than that?
Definitely there is preparation. We will make an appointment for the patient in the place where they are going to live, and I will make sure that he is attached to the local mental health authority, connected to the local mental health authority, so that the patient receives the services they need. And we will also make sure, normally want to make sure that they're going to a stable place of living environment, either to their home or a group home or a nursing home in case if needed, or at least a respite care facility.
And does it take some time and coordination in order to come up with that plan when the person is ready?
Yeah, for a civil patient, yes, it will take some time, normally a week or two, depending upon the situation and circumstances in general. And sometimes if the patient is for home or a nursing home placement, then it may take a little longer, like a few months sometimes.
At this point in time, have you had sufficient time to treat Mr. Gerard in order to bring him to the level where he would be eligible for release?
If he's a civil patient, yes, I would say he's at the level where I can consider for finding the, if he's a civil patient. But unfortunately, Mr. Gerard is not a civil patient or a civil commitment right now. So that makes me to raise the bar or threshold for the discharge process.
Are you recommending to the court that Mr. Gerard have more time in your facility for treatment to see if he can reach that level where he is not a danger to himself or the community?
That is correct. Normally, for the patients on NGRI commitment, there is a process or a procedure called risk assessment evaluation. Should be completed by forensic evaluator. And to do the risk assessment from the forensic evaluator, the patient needs to be under the observation for months, many months, sometimes a year. And to make sure the patient is stable and consistently stable and consistently taking the medicine voluntarily. And if he's having any kind of symptoms like aggression or any kind of symptom like getting angry or any kind of symptoms, we want to make sure that they are addressed properly and stabilized. In some cases, we may give counseling to the patients based on the underlying clinical status. So this is our process takes longer, and the more observation is needed.
Thank you, sir. I'll pass the witness, Judge.
Mr. Lowe, your witness.
Good afternoon, doctor. My name is Doug Lowe, and I represent Robert. And
Yes, sir. Your voice is a little down. Can you?
Yeah, let us get on microphone. That's my fault.
Okay, sorry. I should have moved it.
All right,
Is that better?
Yes, sir.
Okay, I apologize. So I represent Robert. And do I understand that you are his primary treating physician?
Yes, sir.
All right, excellent. Thank you very much. And did I understand when the question was asked that although he's not in immediate danger to himself or others, that you need additional time to evaluate him since this is a criminal commitment for a very serious offense. So do I understand that correctly?
That is correct, sir.
All right, so thank you very much. So what medications do you have Robert on now?
Mr. Gerard, Robert is on a medication called quetiapine. Brand name is Seroquel, which comes under category of medication, and that is the one of the medication that is recommended for his diagnosis.
Okay, and so is he compliant with taking his medications?
Yes.
And does he have counseling sessions and other classes he has to go to there at Big Springs?
Normally, in general, we have classes that are scheduled. In the last couple of weeks, we are in a restructured process. But yeah, in general, yes, we have classes for Mr. Robert Gerard and other patients.
And do you judge that he is doing well in his in participating and doing the things he's supposed to be doing there at Big Springs?
As for the report I'm receiving, he's doing well, except an episode last week where he needed restraint from the staff because he was aggressive toward the other patient. Apparently, other patient was mean to him, making racial comments. That was the only one episode that we came across. Other than that, Mr. Gerard is doing well.
And so what about, when we left here, he was still having hallucinations, visual and auditory. Does he still relate that he's having those issues come?
Mr. Gerard came to us with medication. That medication he's getting now. And I believe that, even before he came here, his symptoms are controlled very well. And he continues to not to have these symptoms.
Okay. And so can you describe for us what your facility is like there at Big Spring? Is it maximum security with guards or tell me what it's like there?
It is not maximum. It is they call, I think, minimum or moderate hospital, state hospital, which means like a psychiatric hospital. It is locked 24/7, and the staff will be there 24/7. The nurse assistants will be observing the patients 25/7, at least every 5 minutes. They have to do checkup, eyeball the patient, make sure that they're doing okay, and they will be provided daytime activities during the and they have some restrictions depending upon their symptoms, like elopement precautions, suicide precautions, all these kinds of things. But it's a regular general hospital, but most of our patients are committed from the jail, either on NGRI or trial competency restoration. So the security levels are higher than a regular inpatient psychiatric hospital.
And so does he have an opportunity to do things to get privileges, commissary benefits and things like that? Does he have those opportunities?
Yes. And after 3 days after admission, he got the grounds access. We call it grounds access, where he can go to canteen in certain hours and purchase things as needed and participate in the program.
And so the purpose, according to your application here, is to ask for additional time and to develop a comprehensive treatment plan. And I guess there's no way to give you an exact time. But I think I heard you say months. Tell me what you're thinking in developing a plan about how long you're talking about.
Normally, 1 month, up to 1 month is the one we request.
And so in a month, another month, do we need to?
And normally,
I think you locked up there for a second.
Normally, we request for up to 1 year commitments
Okay,
after the first 30 days. And Mr. Gerard's situation, I think, just came to hospital, and but his legal charges or his commitment is NGRI with a severe offense, which puts us at a very high threshold to pass the risk assessment. And I think I request for 1 year at this point of time.
so it's gonna take, with the level of his issues that you had to deal with, you think a year is what we're looking at before we need to have another hearing?
Yes, sir.
Okay, and by then you'll have a plan that either will say additional treatment or some sort of supervised release.
Yes, sir.
All right, and that's all I have, Your Honor. Thank you. Pass the witness.
Ms. Craig.
Nothing, Your Honor.
All right, Dr. Reddy, I do have just a couple more questions for you. Do you believe that Mr. Gerard is suffering severe and abnormal mental, emotional, and physical distress at this time?
Yes, sir.
Okay, and do you believe that he's likely to continue to deteriorate and function independently, and that he's unable to make a rational decision with regards to whether or not to take medication or submit treatment?
It's unpredictable. I would say yes, he's at risk at this point of time.
Okay, thank you, Dr. Reddy. Anything further from counsel?
No, Your Honor.
No, Your Honor.
Is it my understanding that counsel has agreed to submit to the court the physician's certificate in treatment for recommendation and inpatient commitment as prepared by Dr. Reddy?
Yes, Your Honor.
So agreed, Your Honor.
All right, then the court will mark this as Exhibit 1 for the purposes of this hearing. Okay, any further evidence, Ms. Curry?
No, Your Honor.
Any further evidence?
Since Robert's there, could we visit with him a little bit, Your Honor?
Absolutely. All right, Robert, I'm going to ask you to unmute there. If you can unmute that device. I believe Mr. Lowe has some questions for you. There we go. All right, go ahead, Mr. Lowe.
Afternoon, Robert. Can you hear me? I guess you can.
It looks like the internet maybe is.
Hey, Robert. Can you hear me?
Mr. Gerard, can you hear Mr. Lowe?
I can now.
Okay, go ahead, Mr. Lowe.
How are you doing, Robert?
I'm doing good.
All right, so did you hear what the doctor talked about just a while ago?
Yes, sir.
All right, and he says you're doing good, but you had a little incident last week. Somebody called you a racist name.
Yes, sir.
Okay, well, we got to control our temper, right, Robert?
Yes.
All right, and did you understand that he feels like he needs as long as a year to continue to evaluate you? Did you hear that?
I heard that.
All right, and are they treating you okay there, Robert? Are you doing okay?
I'm doing good.
Did you watch the Cowboys not be in the Super Bowl?
I thought. Kansas City didn't do so good either, did they?
Well, they did. So, well, I think, do you have any questions for me or for the judge about things? Because I think it's all on you, Robert. You've got to continue
Okay.
better. But do you have any questions for us today?
No, I understood everything.
You sure you understand? So, you're as happy as you can be out there in Big Spring with what's going on with you.
Oh, I'm doing good. I'm getting to talk to my mother every day, and I'm getting to talk to some good people out here. This is a cool little part of the world. It's the first time I've been out this way, so it's not going to hurt to get the most out of it. So I'll be all right.
Excellent. All right. So are you getting to do some recreation, be outside some?
Yeah, when y'all called, we had just went down there, and I got to order some stuff that I needed, some toothpaste and some stuff like that I like. So, and then I came right over here, so I got everything done I needed to get done today. It worked out.
And are you taking Are you taking the shots for your diabetes like you're supposed to?
They're trying to get me off of the shots. They just lowered my dosage from, it was 28 when I got here, then they went down to 20, and now they're down to 16, and they got me on metformin, and they're gonna try another pill tomorrow. So they're slowly weaning me off the shots, which is what I wanted to.
Excellent. Okay. Well, unless you got a question for me, Robert, that's all I have to ask from you.
That's all I got.
Good to talk to you, Robert. Hope.
Good seeing y'all too.
Okay.
Ms. Curry, do you have anything for Mr.?
No, Your Honor.
All right, Robert. It's good to see you. I'm glad to hear Dr. Reddy's report that you're doing well. I understand you had a little incident last week, but that might not always be regarding mental health issues. I understand there's a lot of things like that that go on in the world that have nothing to do with mental health. So I want you to continue doing what the doctors have asked you to do. Follow that treatment plan. Be open with them. Tell them how you're feeling about your medication and about whether or not you're having any hallucinations or anything of that nature. We have you there because we believe that this is the best facility to be able to treat you and to hopefully, get you back to your family one day. And so, as Mr. Lowe said, it's really on you. And the only way that people know how you're feeling and how you're doing is if you communicate that and you trust your doctors and the nursing staff to do that. So I'm glad to see that you're doing well. I'm glad to hear that you're maybe not enjoying being down there, but you're accepting it for what it is and making the most out of it. So I do appreciate that. Okay.
Thank you, Mr. Mark. Judge Mark.
Hey, you're welcome. You're welcome. And I look forward to our next hearing, and I'm sure it's going to be even more good news and maybe a lot better news next time. So keep up the good work that you're doing. Okay.
All right. Thank you. Yes, sir.
Thank you. All right. And Dr. Reddy, do you have anything further that you would like to add?
That's all, Your Honor. Thank you so much.
All right, Dr. Reddy, thank you for being here. If there's nothing further, then the court having admitted Exhibit 1, the treatment recommendation and inpatient commitment physician certificate completed by Dr. Reddy, the court having considered that, the testimony of Dr. Reddy, the testimony of Mr. Gerard, the court finds that Mr. Gerard is still presently mentally ill and meets the criteria for court-ordered inpatient mental health services. The court also finds that he does also meet the requirement for extended court-ordered inpatient mental health services in that he is presently severely mentally ill, and as a result of that illness, he is likely to cause harm to himself or another if not provided with treatment and supervision, that he is suffering a severe and abnormal mental, emotional, and physical distress, is experiencing substantial mental and physical deterioration of his ability to function independently, and is unable to make a rational and informed decision as to whether to submit to treatment. The court does take specific notice of Dr. Reddy's testimony that is not always the case. It's not a consistent lack of a rational and informed decision, but it does change from time to time. Be that as it may, the court does still find that he does suffer from that inability to make a decision to submit to treatment. Further, the court finds that Mr. Gerard, having received inpatient mental health services for at least 60 days during the preceding 12 months, that his condition is expected to continue for more than 90 days. The court finds by clear and convincing evidence that continued mandatory inpatient supervision and treatment is appropriate. So the court does order that Mr. Gerard be and is hereby committed as a patient for inpatient treatment to Big Spring Hospital or any other inpatient facility designated by the Department of State Health Services for a period not to exceed 12 months. The court is signing an order this date, February 20th, 2025, and prior to the anniversary of this order, the 1-year anniversary, the court will schedule another hearing for the attending physicians and Robert along with counsel. So what I'll do, Dr. Reddy, is I'll get this order signed, and Ms. Taberham, a coordinator, will get this sent down to Big Springs Hospital so you can have this for your record. If in the meantime the necessity becomes that we need to have another hearing, just notify the court and we will do so and assist in whatever way we can. So with that, I appreciate everyone being here today. Again, thank you for your patience as we were starting a little bit late. So Robert, good to see you. You keep up the good work. And Dr. Reddy, we look forward to hearing from you. Some good reports for Robert.
Thanks.
All right, if there's nothing further, then we are adjourned in this hearing.
Okay.
reached a settlement in terms of an agreed upon amount of restitution. I asked Mr. Hartwell, but we're not certain if there's a judgment or some type of document that the court would like. for it to
Remind me,
reflect that.
we got to the point of pleading and doing all of that. I just checked the case and I didn't see, I had to try to refresh my recollection. I didn't see plea papers or anything of that nature that we've already signed.
And if I remember correctly, we completed the plea, and we were just waiting for the restitution amount, so you held off memorializing that plea in the judgment for us to get our numbers placed in before you did that. The reason we chose to do that was because there was such a short time between when he actually pled and the hearing was held and today the restitution.
Okay, so did we execute paperwork then?
We did, the only thing that was not executed was the judgment with that restitution.
Does the state have that paperwork still?
Your Honor, I should be able to access it.
'Cause I don't,
Yeah, because he signed and was signed. But I think the clerk's office.
the last thing that I have filed by the clerk is the agreed order authorizing release of grand jury testimony.
Measure it and check with the clerk's office.
That was on the 22nd. When were we here last? We were 2/13, I guess.
Yes, sir.
Last week.
And that's when I was out and Mr. Hernandez was also out. So.
Let me see if Miss Tabraham. Doubt she would have held that, but let me make sure.
If I may, I'm gonna step out real quick.
All right, we are on record, cause number CR 24-184, State of Texas versus Kevin Winford Parker. Today, the court set a restitution hearing at the request of Mr. Parker. It's my understanding that both the state and the defense have reached an agreement within which to impose a restitution amount at $2,000. That amount being payable to the victim, in this case, Mr. David Crouch. Is that the agreement of the parties?
Yes,
That is the agreement from the defense, Judge.
All right, the court having had an amended judgment of conviction by court completed, the amendment being the restitution amount $2,000. The court has signed that this day, and the court is going to have Mr. Parker to be fingerprinted on this amended judgment, and that will conclude our hearing. Anything further from the state?
nothing further, Your Honor. Thank you.
Anything further from the defense?
Nothing from defense, Judge.
All right, Mr. Parker, just stay where you're at, and Deputy Martinez is going to come over there and get your fingerprint. And then if you want a copy of this for your records, we can get you one. Would you like one? Okay. That does conclude the court's criminal docket for today. Court is adjourned.